So, good evening, everyone. I'm very happy to welcome you to today's ÖFG Peaceful Change lecture series. And Peaceful Change, amongst other things, does actually have something to do with international criminal law, topic for today. Because if you think about it, international criminal law, and especially the ICC, the attempts to stop impunity for international crimes, quite revolutionary, actually, if you think about it in the 1990s. But now we're used to having the court, but there are obviously a lot of interesting things happening, including today. And we have a fantastic speaker for today. To my right is Marc Perrin de Brichambaut. There's a lot I could say now about him, former advisor, chief of staff at the Foreign Ministry, Defense Ministry in France, head of the French delegation at the CSCE, head of the legal office in the French Foreign Ministry, and as such took part in negotiating the Rome Treaty and led the delegation of France to sign the Rome Statute. And he was then Secretary General of the OSCE here in Vienna from 2005 to 2011, and then was judge at the ICC in The Hague from 2015 to 2024. So please join me in welcoming Marc to today's lecture.
Thank you very much, Marcus, and I'm very pleased to be with you today and try and share with you some experiences about international criminal justice. I just confessed to Marcus that I was going to give you a standard talk, and assuming you already all know quite a bit about the Rome Statute and international criminal justice, and it might have been a little bit of in a dark mood because, as I mentioned to him, I would end up saying that there are 7 of the judges which are under arrest warrants from Russian courts, and the prosecutor is under sanctions from the United States with an executive order specifically designed for the court, and that there is a HS-23, the first piece of legislation adopted by the new House of Representatives, specifically targeted on the ICC, which has already been voted on by the House of Representatives, so we're just waiting for Senate confirmation, and which provide a mandate for the elimination of the court, to be more or less, but I won't tell you very much about this, because today is a very special day. Today is a very special day because for the first time in many years, a former head of state is on an airplane going to The Hague. And this is only the 3rd time it happens, if you allow me, in history. The first one was Milosevic, quite some time ago. Second one was Gbagbo, and former president of Côte d'Ivoire in fairly delicate circumstances. And now, on the basis of an arrest warrant, which was issued by the pretrial chamber number 1 on Saturday morning, this morning when Mr. Duterte landed in Manila, there were no less than 7,000 police people who had been deployed to welcome him. He was arrested, and apparently he was promptly put on an airplane. Now, we have to keep our powder dry. We don't know where the airplane is going. We don't know who has the airplane. And until the airplane has landed in Amsterdam and Duterte is in the Scheveningen prison, we have to keep our champagne in the fridge. We can't really drink it immediately. So I've changed my approach, and I've decided that I should basically make this presentation today on the basis of the story of the relationships between Philippines and the International Criminal Court. And this is a sort of case study approach which allows, in fact, to read through the statute on the basis of its practical implementation over the years by the first prosecutor, by the second prosecutor, by the third prosecutor, by the judges, and of course the attitude of the states, which are still the driving force. This is I'm not going to spend too much time on this, but the Rome Statute remains a combination of three factors. Factor number one, the states take the commitment to go after major crimes in their own judicial and legal, and their own legal and judicial order. It's about commitments taken by the states for themselves. So whenever I used to welcome visiting judges in The Hague, I would tell them first thing, you are the international judges for criminal law. It is your responsibility to go after them. The major crimes, crimes against humanity, war crimes, and genocide have been codified in the statute. Normally, you should have integrated them in your own legal system, so you have responsibility to go after them. The second element is that it is an international organization in the sense that it is a treaty-based, run by states, funded by states, entirely dependent on states to implement its mandate. If the states are not willing to provide the support for the court, there is no investigation on the ground, there are no witnesses, there is no arrests, there is no possibility. We're going to see this right now with the what happened in Philippines over the years. So, and it's not a universal organization. It is an organization of 125 states now, but without the support of the US, without the support of Russia, without the support of China, without Turkey, without Israel, and with quite a few of the Asian states missing, but with a core support from, let's say, Francophone Central and West Africa, and Western Europe, Eastern Europe, Latin America, which have historically been the core political and financial support for the court. And then it is a court of last resort. In other words, if the states do not do their duty, either through states or through the Security Council or on the initiative of the prosecutor, the major crimes can be sent to this court. It's a complicated process. We're going to see it in the Filipino case, but it's a real judicial process with set procedures, with guarantees for the accused, with guarantees for the victims, and with a step-by-step process, which is very sensitive. So you all know the background of the ad hoc tribunals which happened. This is really the quintessential elements of the Rome Statute, an international treaty meant to work in complementarity with national systems. This is the idea. National systems have the central responsibility. Court only intervenes if the national systems fail to do their job. And there are 4 specific crimes, and it's about individual criminal responsibility. It's certainly not about states. We will, if we have time, make a footnote on the current role of the International Court of Justice, which is de facto progressively getting involved in international criminal justice for different reasons. How does it work? And this is important, because this is in a way the synthesis of how the different cases have been handed over to the court. And you have an accumulation of at least 3 different layers. The initial layer, I understand Luis Moreno Ocampo was here a year ago, was a product of the choices of Luis Moreno Ocampo. I do, if you forgive me the word, deals with heads of state mainly on the African continent, and they give me jurisdiction to address certain cases. So, in effect, for 15 years, the court has been working on the basis of cases handled by Uganda, Central African Republic, DRC, Mali, Ivory Coast, and to a certain extent, Guinea. So this is how the pump was primed by Moreno Ocampo. Otherwise, the court may have waited for quite a long time before they came. So this is what I call here self-referrals. By the way, a self-referral is not in the statute. Don't look for it. It's a Praetorian creation by the prosecutor, which was accepted by the judges, and it was never challenged by the states. So the states, in a way, bear a lot of responsibility for letting things happen. Then, in a moment of grace, the United States allowed the Security Council twice to use the provisions of the statute, which allow the court to get involved in Darfur and in Libya. So it's the Security Council Chapter 7 resolution which asks the court to get involved. And then there is what was the subject of a big fight in the negotiation of the Rome Statute, the possibility for the prosecutor to initiate prosecutions when he feels the states are not doing their job. So he makes an assessment. He considers that there is not proper implementation, and then he goes to a pretrial chamber and asks the pretrial chamber, please, can you authorize me to initiate an investigation for the crimes which I believe are within my jurisdiction, which are not being properly addressed and prosecuted in that country. Philippines is one of those, but the prosecutor also did it in Georgia, in Kenya, in Burundi, and in Afghanistan. Now, this, if I may say, phase one was basically the self-referrals and the UN Security Council. Phase two, to a certain extent, was the initiatives by the prosecutor. Phase three is where other states do what is prescribed by the statute and ask the prosecutor, say, something is going on in another state, you better have a look at it. I believe you should investigate. So the absolute first one to do was Comoros in a small case. We won't have time to discuss it, but which was relevant to a flotilla of boats which wanted to provide humanitarian assistance to the Gaza Strip. But the first big one was 6 Latin American states, which asked the prosecutor to get involved in Venezuela, Ukraine, 2014, 2015, and Palestine, 2018, altogether. So this is just as a reference. I'm going to go, with your permission, straight to the. I can't skip, of course, the face of the prosecutor. Prosecutor is the engine of the court. He is the one that makes the strategic choices. He has limited resources, but he gives orientation to where those limited resources are going to go. He has an enormous responsibility because he has to determine where there are cases which have a good chance of being symbolic, have a big impact in terms of public opinion, in terms of what the victims are expecting, and where he has a good chance of getting enough support from the states in order to get an arrest, in order to get witnesses, in order to get evidence, in order to have a proper legal procedure. This is complicated because an average serious case in the court takes 10 years altogether. Between the moment the accused arrives, if he arrives today, well, at best, Mr. Duterte will be there for 10 years. Gbagbo was there for 10 years before he was acquitted by the fully acquitted by the appeals chamber. Same thing for Bemba, who was also acquitted, who was not a head of state, but who was acquitted after having spent 10 years. But Bemba did a few other things which were not nice altogether. So Karim Khan, third prosecutor, dressed up as an English barrister, you will have noticed, for those who are interested in those things. The judges, 18, very different backgrounds. Here I think we still I'm trying to see him. No, we don't have the Filipino judge. It's not the last. I'm still in, which I shouldn't be, but it's the accused, Mr. Bemba, the defense, the legal representative of victims. If you don't know her, she's married to a famous actor, so it's your bet. But I will come back to now Philippines. Philippines in 2011 signs and ratifies the Rome Statute. A bit late in a group of states, the Asian states, where there are not many states which have signed and ratified the Rome Statute. There's basically Japan, South Korea, and a few Pacific islands increase the group. So when the Philippines joined, everybody was extremely happy. It was a great event. And immediately there were elections for judges every 6 years. Every 3 years, 6 judges are elected. It's pretty easy to get elected in Asia because you have so few states and you have 3 judges. Immediately the Philippines put forward a candidate, a senator, who incidentally was not a great friend of the then president, a certain Mr. Duterte. So Mr. Duterte sends somebody he doesn't like to the court and nominates her, and she gets elected. She's number 1 elected judge. So she's the first of the 6 to be elected. Problem, she doesn't want to go to Vienna, to The Hague, sorry. She stays she never takes her oath. She stays in Manila in the Senate. So the poor president of the court, after a number of years, tries to make sure that he has a judge from Asia and convinces her to resign. So she resigns, and another judge, a senior law professor, Raul Pangalangan, which I worked on a few cases, is elected to finish the term. So there was for 9 years a Filipino judge, but it was not Judge Miriam Santiago, it was Judge Pangalangan. But in between, the prosecutor in 2015 starts to get interested in what is going on in the war against drugs, which was started by the mayor of Davao, a certain Mr. Duterte, who proceeded by summarily eliminations on people which were considered to be drug traffickers or drug addicts. It's very hard to know how many individuals, there were different evaluations, were eliminated over the years by Duterte, either in the city of Davao or afterwards when he became president in the whole of the Philippines. There are estimates which go up to 30,000, but probably at least 6,000 or 7,000. So it was a major operation, and needless to say, the Filipino judiciary was not encouraged to go after potential culprits. So the Office of the Prosecutor received a lot of inputs from NGOs in the Philippines, started to look into this. There's a special office, not a very big one, but a special office that looks at these things, and determined in 2018 publicly that there was room for an invention of Moreno Campo, a preliminary examination. A preliminary examination is an extrapolation of the statute, where the prosecutor determines that he has to put on notice a country that he believes crimes within the jurisdiction of the court are being committed, and that therefore, because those crimes are being committed, he is paying particular attention and making it public. So if you look at the booklet of the Office of the Prosecutor in 2018, you will see there's 3 pages dedicated to Philippines. And there is a dialogue at this phase of preliminary examinations where the prosecutor tries to talk to the authorities and says, can you give me explanations? Why are you not doing more? Couldn't you do more? Couldn't you have a real policy trying to investigate and to follow what is going on? Because I do believe very serious things are going on. So it's not very clear, honestly, from what is in the preliminary examination booklet, how much of a dialogue there was with the Duterte administration at that time. Probably not much. But there is in the Philippines a very lively NGO community, and they took risks. They assembled evidence, and they sent it regularly to the office of the prosecutor. So in 2018, the preliminary examination is formally open, and in 17th of March 2018, Duterte obviously thinks that things are getting a bit hot, so he withdraws the ratification and the signature of the Philippines from the Rome Statute. But the statute provides that the court keeps being involved with a state that withdraws its adhesion for a year. So in effect, the court has full jurisdiction until the 17th of March 2019 on everything that happened in Philippines. So it's amply enough to allow the prosecutor to build up cases potentially. It still takes a little while for Fatou Bensouda, the second prosecutor, to get her act together. And it's only on the 24th of May 2021 that, using this provision of initiative by the prosecutor, the prosecutor goes to the pretrial chamber and asks for permission to formally open an investigation. This is Article 15 of the statute. This was secret, and this becomes important when we're going to look at other cases. The normal practice of the court is that when you ask for the opening on an investigation or you ask for an arrest warrant, it is secret, because you don't want to embarrass the judges. The judges should not be pressured by having a public statement pushing them to do something. We will see that this, regrettably, this sound practice is not really active anymore. So it's only on the 14th of June that a version of the request by the Office of the Prosecutor, which is redacted in order to protect names, to protect individuals, is published. The judges normally take their time to look at all the evidence. There are exchanges between the prosecutor and the Filipino authorities, and the authorization to open an investigation is granted on the 15th of September 2021. You will have noticed that this is after the end of the period in which the court has jurisdiction. So by being extremely slow, by taking almost 2 years after the end of the jurisdiction of the court on the Philippines, the prosecutor has done something dangerous. He has exposed himself to legal arguments that he should have initiated the investigations while the court still had jurisdiction, and not have waited. I will explain to you it's an argument that has been made in the procedure, and it's an argument that is going to come back very much when the whole case hopefully comes back to the judges. But then the Rome Statute has been built on a balance between the protection of the sovereignty of the states and the potential authority of the court. And one of the provisions that ensures that balance is Article 18. Whenever an investigation is opened, it is circulated to all the participating states so that they can give their opinion. And there is a possibility for the state involved to ask for a freeze for 6 months. So immediately the Philippines asked for a freeze for 6 months, and the investigation was halted. This has been increasingly used. It's been used by Venezuela, it's been used by Afghanistan, it is currently being used by Myanmar. It is a way for the states to give themselves time to provide arguments to the chamber, to the pretrial chamber, that no, they are effectively doing their job. They are effectively prosecuting those crimes. I've been involved in a couple of these. It's open for questions whether 6 months is enough to put together a semblance that the states are doing what they are meant to do. But then the OTP has to come back and again go to the court and say, I would like to restart the investigation, which the Office of the Prosecutor did on the 24th of June, 22. And there was a further exchange between the Filipino authorities and the prosecutor, and the pretrial chamber granted authorization of resumption of investigation, to which immediately the Philippines said, I'm going to appeal. I disagree with the decision of the pretrial chamber, and it is appealable, so they went to the appeals chamber. It happens by coincidence that I have a certain understanding of what happened in the appeals chamber because I presided that appeal with my 4 other colleagues, and we took time. We looked at everything, and the appeals chamber by majority confirmed the decision of the pretrial chamber. In other words, it said, yes, the court still has jurisdiction over those events that happen in the Philippines, and they can be prosecuted. And 2 judges said no, because the court started far too late its request for investigations. It lost its opportunity. And I'm sorry to say that I happen to be of that opinion with a judge from Georgia, but the majority said that the court has jurisdiction, so by definition we respect the determination of the majority, so it's a judicial decision now that has been fully confirmed. But why do I mention this to you? Because this is a sort of argument which is likely to come up in the next stages of the judicial procedures. And then things brutally accelerate. And what I'm describing here is what has happened in the course of the last 4 days. After a request which happens on the 10th of February, the OTP requests under seal a warrant of arrest for former President Duterte. Only him, only the head. This is, if I may say, the characteristic of the third phase of the life of the court, which was initiated basically with the arrest warrant for Vladimir Putin. The policy of Karim Khan is to go straight to the top, which is a very risky legal procedure, because both Bemba and Blé Goudet were acquitted because it was very difficult for the prosecution to prove that they had given orders for the crimes that were committed to be committed, that they were aware of it, and that they did not do something to prevent it. So the issue of the chain of command, the issue of command responsibility, particularly for war crimes and even more for genocide, is an extremely delicate legal issue, but it's the choice of Karim Khan. He's done it again, you are aware of it, in Palestine. He did it in Myanmar for the head of the junta recently. He did it in Afghanistan for the head of the Taliban Governing Council, and now he's done it for Duterte. There are difficulties, of course, because the chances of arrest warrants against acting heads of states are debatable, let's put it that way, and even for former heads of state, the chances that they might get arrested are not certain, but maybe today Karim Khan is in line with the year of the snake and is scoring a hit. So on Saturday, the three judges of the pretrial chamber issued an arrest warrant against Duterte for crimes against humanity committed both when he was mayor of Davao and when he was president. And I give you the content because it's important to know this, after all, is a judicial work. You have to understand how things are. The arrest warrant, which of course was secret. And how do I know what is in the arrest warrant? Well, I will share it with you, because if you want to read the arrest warrant, you don't go to the website of the court. It's secret, so it's not there. You go to the Manila Times, and they got a copy, probably from the police, and I therefore read it this afternoon at 4 o'clock from the Manila Times. But this is slightly worrying, because it's not meant to be public, and the fact that the arrest warrant is entirely public can have also legal consequences. So the arrest warrant says that the judges have reasonable ground to believe that murder as a crime against humanity under Article 7(1)(a) of the Rome Statute were committed, 19 in Davao, 24 during the presidency, out of how many thousand? Well, that's the constraint operating on the court. The prosecutor can only put forward crimes for which he has enough proof, where he knows he will have witnesses. It's well enough to go after Duterte, but it's only an infinitesimal fraction of the crimes which were probably committed under his responsibility. So since this is a crime against humanity, the arrest warrant says it's part of a widespread and systemic attack. In the statute it could be or, it's and. And there is a personal individual responsibility because he had control, Duterte, of the Davao group and has supreme commander of all the police forces. He had responsibility above the Filipino National Police. And of course, the mode of responsibility is also very important. He made an essential contribution to committing the alleged crimes, sorry for the typo, under Article 25(a), with intent and knowledge. All the lawyers among you knows what this means. Mens rea, he knew that it was going to happen. Now, the prosecutor asked for two other categories of crimes to be part of the arrest warrants. And they were not granted by the chamber, but torture and rape. And the chamber, I think, considered that there was not enough proof in the file to put them in the arrest warrant. So chamber shrunk already to a certain extent what the prosecutor is going to go after. Now, of course, that's where things become interesting, because you will say the prestige of the court is such that as soon as the arrest warrant was received, everybody rushed to implement it. Well, there are quite a few arrest warrants going around from the court which are not being implemented. I can tell you I signed quite a few of them. They are secret and they're not being implemented. So why was this one implemented so quickly? Well, perhaps because of domestic politics. I'm just a hypothesis, domestic politics within Philippines itself. Perhaps because at a certain moment the president wanted to get rid of the clan of his vice president, which is the daughter of Mr. Duterte, and made sure that things would go very quickly. Well, of course, Mr. Duterte, the lawyers of Mr. Duterte today rushed to the Supreme Court of Philippines, requesting the cancellation of the arrest warrant. But from what I read, source CNN, Duterte is already in an airplane. Now, I don't know, no source says where the airplane is going, whether it's going first to a country which is a active member of the Rome Statute, which would probably be an intermediary before he can be sent to the jail in Scheveningen. We will see, or or it can be a friendly country where he's going to be hiding for a while. The great uncertainty going on. But the reason I went through this whole sequence is for you to understand how basically the relationship between the states and the court is a complicated one. It is run by the provisions of the statute. It depends enormously on the goodwill of the states. I don't know who provided the airplane, but I know who provided the airplanes for Milosevic and for Gbagbo, and in itself, it's a big challenge for the court to find somebody who will provide an airplane for bringing over an accused, because it carries a certain amount of political risk altogether. So let's see. I checked with the French. I can tell you it's not the French, so which usually have been doing those things in the past. So this, having said a few things about the Philippines, I know that you will also be interested in what is going on in Ukraine and potentially in Palestine. So with your permission, I'll say a few words about these, because they're on the minds of everybody. But the toolbox which we have looked at in Philippines are very useful to understand. Ukraine was until last summer not a member of the Rome Statute at all. However, after the Maidan events, after Crimea, after Donbass, it had requested the court to take responsibility, and it had given the court jurisdiction to investigate, and therefore the court has had jurisdiction over Ukraine since 2014, 11 years. What happened between 2014 and the 22nd of February of 2022? What did the prosecutor do? Nothing. Prosecutor has complete discretion about whether or not whoever initiates the procedure, whether or not to go ahead. So, and you understand why the prosecutor has to be selective. He has limited resources. There is somebody here in the room which is probably one of the few persons who knows how many investigators there are in the office of the prosecutor. And I found out once in my 9 years. So it's a great secret, but he doesn't have that many investigators. And he has to deal with, I'm going to show you a map of the world, he has to deal with all those situations across the planet. So you see the countries which are under preliminary examination, and you see the countries where the investigation is still going on. And so he has a few dozen investigators, he has a limited number of lawyers. Since 2016, practically the real value of the budget of the court has been quasi-stable. The court barely got enough money to cover for inflation. And we're going to see how this was handled in Ukraine. So the prosecutor decided that whatever resources he had could not be usefully invested in Ukraine under those conditions. Of course, when 22nd of February 2022 happened, when there was an armed invasion of Ukraine, things changed. The pressure was much bigger, and on the 3rd of March, 43 states, including Austria and whole of the European Union and a few other states, requested the prosecutor to get involved in Ukraine. So this was, if I may say, the high moment of Karim Khan, because he was riding a wave with enormous support for the involvement of the court. He had the support of the United States. He had the support of a bipartisan support in the United States. He had 6 senators which came and spent a day specifically at the court I will not name them because you would ask too many questions afterwards, who to show support for the activity of the court in regard to Ukraine. He asked for voluntary contributions from states, from the EU. He asked for personnel to be seconded. He got more or less, not quite everything he wanted, but a lot of what he wanted. What did he do with it? Well, he spent part of it setting up an IT capabilities with a company called Microsoft. And we will see that this might be a slight problem under current conditions altogether. So the prosecutor was able to have a critical mass of resources, and at a certain moment, he made the strategic choice I mentioned. He says, I'm going to go straight to the top, and I will go straight to the top using something which has a great appeal on public opinion. So he did not go straight to the top on war crimes or crimes, on one category of crimes against humanity, which is the kidnapping of population and of children, and the transfer of population and particularly of children. It is on that basis that there is an arrest warrant for Putin and for Maria Lvova-Belova. As I mentioned earlier, the consequences were immediate. The prosecutor and the judges now have to go around in armored cars and are under police protection. And there was a cyber attack on the court. But nevertheless, the prosecutor continued, and there are 4 more arrest warrants of senior Russian officials, which have been requested, adopted by the pretrial chamber, and made public. So the chances, of course, that those guys, which, you know, Gerasimov and company, are ever arrested are rather slim, but nevertheless, there is now a sort of world stage dimension. Those people are considered as criminals which are being sought, and their freedom of movement is therefore limited. But the number of crimes being committed in Ukraine is immense. So there is probably already in the files something like 120,000 war crimes which have been identified altogether. This means that the role of the ICC, by definition, is going to be very limited. And this is why the prosecutor has practically said that he would focus on 3 categories: the crimes against transfers of population, the crimes on the environment, and the attacks on civilian population. But the rest of the war crimes and crimes against humanity, he leaves to the Ukrainian tribunals, which continue to have full jurisdiction. It's going to be complicated because an international trial, you understand, provides far many more guarantees than what the judiciary of the Ukrainians can afford. But still, there will be a sort of parallel. This is complementarity, but in an horizontal way. Instead of the court taking over when the state does not do it, it's the state, the court, and other states acting under universal jurisdiction, working together in a cooperative mode. Eurojust in The Hague is also very much involved in this. Now, I'll just give a few words on Palestine. On Palestine, you will forgive me, I did not make a slide. I'm cautious. I know this is a highly controversial issue. There are strong feelings of all sorts, so I'll just stick to the fact. The good life of the prosecutor ended on the 7th of October of 2023. Because as of the 7th of October 2023, there is a case which is much more divisive in terms of the state support for the court. There is a very strong separation between those states who feel that the court should never get involved in this, and those states who have requested the court to get involved in this. And it so happens that part of the states which were supportive on Ukraine and part of the states are split themselves. So there are a number of Western European states which are against the involvement of the court in Palestine and have said so quite openly. There is a group which is in favor. And of course, there is a large group of states coming from the so-called Global South. I have no illusion of what it means, but it's just for sake of simplification, which are very supportive and of the involvement of the court in Palestine and not so keen to put too many resources on Ukraine. So there is an issue of balance within the court, which is an important issue. But the issue of cooperation, how is the prosecutor going to get his evidence? How is he going to get his witnesses? How is he going to build cases against individuals? He has, of course, the support of the NGO community, including the Israeli NGO, but the Palestinian authorities who became part of the Rome Statute in 2015 and gave full jurisdiction to the court in 2018, have been the most frequent visitors to The Hague. Practically the foreign minister of Palestine has been in The Hague every 2 or 3 months, each time bringing new stuff, asking the prosecutor to go ahead. Prosecutor, before the 7th of October, had adopted an attitude regarding Palestine, which was not unlike his attitude regarding Ukraine. This is a sticky one. I don't want to get into too many problems. I'm not going to put too much resources into this. And he had tried several ways of gaining time, one of which was to ask a pretrial chamber whether he had or not jurisdiction on this. Pretrial chamber by 2 to 1 gave him jurisdiction on this. I'm sorry, I wasn't one of the two, but I'm on the record for this. But we already had a foretaste of the great interest by one country in everything that was, as judges, that was going on within the court, I can assure you. So those people are serious professionals altogether. But now the issue is, of course, very complicated and very divisive. And this is where Karim Khan has been drastically innovative. He publicly asked for arrest warrants against 5 individuals, 3 Hamas, 2 Israeli, without precedent, to ask publicly for arrest warrants. Because of everything I told you, as a judge, I find it extremely disruptive and offensive. And not only did it publicly, but he asked for 6 common law judges to confirm that he was right in making this request. In other words, he gave them all the evidence he had. Another thing which, in my Roman Germanic soul, is very, very unusual, to say the least. And he publicly told the judges that they better be quick because it was urgent and serious. He had the Putin arrest warrant in a month, so he thought that he would get the arrest warrant for the 5. You know the storm that they created. I will not elaborate on it. Actually, 2 judges determined that they didn't want to get involved in this. So the chamber had to be recreated. And ultimately, the chamber did give the arrest warrants. 3 of those have already been eliminated. You notice then when the 3 Palestinian accused were eliminated, you did not hear one single voice that said, oh, but by the way, they were in a judicial procedure. Shouldn't they have had the benefit of a fair trial? And a fair trial would have had the immense advantage of showing the world what had happened. No. Everybody, apparently, at least in the media, find it quite appropriate that they disappear. The other 2 ones, you know who they are. I will not elaborate. They have now highly placed friends. So this is where I come back, and I'm going to stop very soon, to my initial statement. The court is again threatened by sanctions from the United States. Trump 1 had sanctions Fatou Bensouda and Fakiso Motochoko. They managed to survive and to operate thanks to the very determined support from the host state, the Netherlands, which took risks because there was a risk that it could be under secondary sanctions. They took the risk and they allowed Fatou to continue to work and to do her job. They were a little mean. Whenever she had to go to the Security Council in New York, she had to go in line in the consulate in Amsterdam and wait in line for a day to get her visa. Nice gesture, of course. But what expects the court is if HS 23 comes into force, it's potentially devastating because it would not only be individuals, it is possibly the court as a whole, which would be untouchable for any American entity. So any American citizen cannot cooperate, any American entity cannot get involved, including, of course, IT companies, banks, insurance companies, social security, airlines, you name it. So the court would be potentially paralyzed. And so this is where the joker has happened today. Something new has happened, which is Duterte. I don't know how this will be perceived by those who are in a position to provide new sanctions. It's your guess. Your guess is as good as mine. Perhaps it will encourage them to go ahead. Perhaps it will discourage them from going ahead. I have no idea. But in a way, my conclusion is that the ICC is currently sort of the canary in the mine. It's the most sophisticated element of the sort of the Kantian world of the rule of law, of cooperation, of providing protection of human rights and providing justice. It's the most sophisticated approach to that has been devised. Of course, we all know that the current mood around the world is a bit recessive in terms of Kantian ideal, and that our friend Mr. Hobbes is currently making great headway in many ways. So if the court manages to survive, it will be a symbol that hopefully can cross the most difficult moments. It is mortal, like all international organizations, sadly, and might have to be reinvented if it gets too bad a hit. Thank you very much, and I hope I didn't take too long, Markus.
Well, feel free to sit down. Thanks a lot for a great talk. I don't even know how long you took because the following the talk was actually very exciting. I didn't look at my watch once.